Friends, we are going to start now. It's a 148th Friday group meeting. Today's topic is the interplay of customs, foreign trade and foreign exchange laws in international trade in India. The speaker is our beloved friend, promising advocate, Mr. Srinivas Kotni.
Thank you, sir.
He had his Lexport law firm is doing very well. When earlier occasion also he addressed on GST and consumer perspective. So that was at 112th Friday group meeting. Thank you very much. This was the book. It was in cartoon form. He was himself wrote, and this is the book. I mean, it's available. He presented to us. We given to library too that time. This is one author. All in cartoons. Easily way to get it in the next. So now we'll go by one. His video already is available in YouTube channel, our YouTube channel. We'll go one introduction, then we'll come back.
Sure.
My name is G.Seshagiri Rao.
Nitin Kumar.
Okay.
Ruma Pathak.
I am also.
Kumar sir, Amit Pratap sir, Avnish Patil,
Subhra Saha.
First of all, thank you, Sekhu sir, for finding me worthy enough to call me the second time and giving me an opportunity to interact with all of you. It's homecoming for me. So the first time I stepped in Supreme Court was in the year 1995, and I'm happy to be back among colleagues, sharing little bits of knowledge which I've gained on the way, and I'll be happy to keep the session more interactive like I did the last time. I don't want to wait for the questions till the end. As and when those questions are there, I'll be happy to address them if I can. So the topic which you gave me today is a very interesting topic, because finance is the lifeblood of any economy, any country, any company, any family, any individual. We are all here to make money to support our families. Similarly, the government has to support the family, which is 140 crores population. So the revenue has to come from somewhere. So therefore, there are various means of getting that revenue, and taxation is one such means. So we have both direct taxes and indirect taxes. So foreign trade is something which individuals in the economy undertake. Even the government undertakes foreign trade. Foreign trade is nothing, I mean, it's all jargon which we create. It's just mere selling and buying of goods, like what a shopkeeper does. Here it's only cross-border. In foreign trade, the entities involved belong to different countries. So because the jurisdictions are there, two different jurisdictions or multi-jurisdictions are there, there will be some complication in law, complication in taxation, procedures and things like that. So from the Indian perspective, how the law plays is what we'll understand. It's a generic topic. I have not taken any specialized topic within foreign trade, within FEMA or within customs or within FTDR Act or within foreign trade policy, etc. But how the entire interplay happens, how do we need to, as lawyers or as businessmen or as citizens, if we want to undertake foreign trade or if we want to give consultancy in foreign trade, we need to know the basics of the game. So we'll be talking about the basics of the game only. So we all know that even in the past, olden days, when anybody visited a new kingdom, the king would ask, what gift have you got from me, right? So that tradition continues. Now the custom, the very word custom means something which is customary, right? So therefore tax in that form is customary, trade in that form is customary. If you look at Kautilya Arthashastra, you have so much on interstate trade and all that, and how it will help the economy of a particular kingdom. So the same thing, now we are in the 21st century, etc. But the aspects remain the same. The individuals, the human beings are the same, the dynamics are the same, the profit motive is the same. So when you want to create that profit, you need to export goods or import goods. And not only goods, these days export services and import services. So when you are doing this export-import, how would you do? What is the law under which you are doing it? Constitution of India, definitely, I mean, the duties, cross-border duties or custom duties is a central subject, right? So therefore, the union government only can levy import duties. But there's an interplay of different ministries in it. There's Ministry of Commerce, which wants to look at India and see India at the top of the commercial order internationally, and Ministry of Finance, which wants to collect revenue out of the commerce which happens. Now all this is facilitated through different legislations. But I'll first talk about Foreign Trade Development and Regulation Act 1992. It's a small act, right? Government of India wants to regulate foreign trade to develop it. Because if you look at it, before opening up, before liberalization, export promotion was very important. Every decision of the government, every speech of the finance minister, everything was for export promotion and import substitution. Now things have changed. 1991 we got liberalized and we became more receptive to foreign investment, foreign investors, brands coming in, and we going out, foreign direct investment and overseas direct investment, ODI it is called. So under the FTDR Act, I would want to read what you call the preamble, right? It's a 1992 Act, an act to provide for the development and regulation of foreign trade by facilitating imports into and augmenting exports from India and for matters connected therewith or incidental thereto. Whenever there is export import, we think it's only customs law. I'm sorry. Apart from customs law, we need to be very wary of FTDR Act, Foreign Trade Development Regulation Act. There's some definitions which are very, very important. What is import? I mean, customs law has a different definition. Foreign trade policy has got a different definition. FEMA has got a different definition. FTDR Act, which is at the fountainhead. If the government wants to allow any imports into India, it has to be through this act. If there's any prohibition, there's any regulation, the fountainhead is this act. Now what is import here? Import and export, both are defined in relation to goods bringing into or taking out of India any goods by land, sea or air. For landlocked countries where we are neighboring countries, road also is coming, right? Land, sea or air. In relation to services or technology, because we spoke about goods and services. Let's not forget services is a very important thing. If you look at TRIPS, agreement on services is a very important agreement. Now today we have insurance, we have banking, we have logistics, we have so many services which are all bringing money to the country. Now with regard to supplying services or technology from the territory of another country into territory of India, that is from other country to India, in the territory of another country to Indian service consumer. So if Indian service consumer is there in another country, that also is covered. By a service supplier of another country through commercial presence in India. For example, some supplier is there who has got a liaison office or a branch office or a project office in India, that also is covered. The other thing is, by a service supplier of another country through presence of their natural persons in India. We travel out, travel in, travel out and provide services. If I'm a lawyer, if I'm going to London and arguing an arbitration matter, this supply of services, right? So those aspects are also covered. Then services, supplying services or technology from India into the territory of any other country. It's reverse now. Reverse, exactly reverse. Somebody from London coming here and arguing a case, or somebody coming here and setting up an insurance business. So all these things are export and import. Now, this act, why is this act framed? This act doesn't want immoral things to come into India in terms of goods or services, or to go out of India. There are many reasons why regulation can be there, but what is important is specifies goods or services or technology. They want to regulate specified goods, specified services, specified technologies. Now we have dual use technologies, we have weapons of mass destruction, we have defense, atomic energy, etc. If there is no regulation, I get some uranium part or some part which is needed for a nuclear reactor. And if there is no regulation, what happens? It's havoc. It will land up in wrong hands and it can be threat to national security. similarly in services sector domain, encrypted technologies. Like everything is e-commerce today, electronic, everything is digital. So therefore everything is happening encrypted manner. So if there's no regulation, that encryption may lead to booby trap for the country. Now, what is this specified goods or services or technology? Means the goods or services or technology, the export, import, transfer, retransfer, transit and transshipment of which is prohibited or restricted because of imposition of conditions on the grounds of their being pertinent or relevant to India as a nuclear weapon state, or to the national security of India, or to the furtherance of its foreign policy, or its international obligations under any bilateral, multilateral, international treaty, covenant, convention, or arrangement relating to weapons of mass destruction or the means of delivery to which India is a party, or its agreement with a foreign country under the foreign trade policy formulated and notified in the second FTDR Act. So we are a party to many conventions. So for example, if you want to export to say Syria or Iraq or Iran or North Korea, any defense equipment, etc., some exceptions are there, but their regulation has to come in. We are signing UN resolutions day in, day out, being in the international community. How to implement them? That implementation is through this FTDR Act, right? And for what purpose? For dealing with specified goods or services or technologies. So this is what is a major motive. Apart from this, many other things are happening under this Act. Then there is technology. What is technology? Can anybody tell me here? What is technology? What do you perceive to be technology? Let us make it interactive. Excellent. Know-how about?
Technology, science and other things. Technology.
Okay. So, I mean, you're almost there. Any other answer?
Which can do anything, any work faster than
Innovation.
normal human
Innovation.
innovation.
Yes. Any other input?
Which reduce the human effort.
Human efforts.
Which reduce.
Any human efforts is technology you're saying.
Not all. Which reduce the human effort.
Which reduces the human effort. Mechanization. Okay. So let me not take it too longer between you and the definition of technology and in this Act. It says technology means any information, including information embodied in software, other than information in the public domain, that is capable of being used in the development, production or use of any goods or software, development of or carrying out of an industrial or commercial activity or the provision of service of any kind. So therefore, whatever you said, I mean, if you have seen Three Idiots, it's something like that. So anything which makes human effort faster and automated, including software, is technology. And technology is the major import these days. I mean, I remember when we were doing those customs matters in the 90s, there is an entry 49.01 under the customs tariff, which provided for drawings, plans and drawings, right? And all these technologies were coming in after liberalization. Many companies were being set up and hundreds of crores was going out of India for transfer of technology. So the customs department saw a very good chance to impose customs duty, which was about 35% at that point in time, on technology import in the form of plans and drawings. So therefore we were fortunately working on that. I'll tell you how law and technology and all this helps, and also the little knowledge how you can negotiate situations. So therefore the demand was hundreds of crores. So nobody had any clue because it's a open and shut case. The book said plans and drawings 35%. What came in was plans and drawings. Without plans and drawings, no technology can come. You can't make a plant. You can't specify where machinery will be installed and how it will be handled and all those things. But then the demand came. The client had come to us. So he said that how do I say my customs duty, which is about 100 and odd crores for technology. It's about 30% of what they paid to the foreign principal. So what we did, I mean, Atulji was there with me at that point in time. So we poured through all the notifications. Today we have at the press of a button, we get all the notifications and all the law. But those days, 94, 95, 96, 97, you had to pour through the volumes. You had notifications, exemption notifications. So we went through notification by notification. And then after spending about 2-3 days in the heap of books, we could reach one notification in one entry which spoke about printed books. It said printed books, nil, import. If somebody wants to import books, nil. Then we thought, what is book? So we asked the client to bring the samples. So the samples were like these folders. If you look at these folders, in those folders is loose leaf, index and page numbered, and except for ISBN number, it has all the features of a book. Then we did backward research, looked at Supreme Court case law, scientific engineering and all that in the income tax context. What are books? For the purpose of depreciation. You are buying books, whether depreciation is available or not, whether books are plant and machinery or not. So in that context, book's definition was interpreted by the Supreme Court. What is a book? It should be serially numbered. It should have different pages. It should be clearly bound, right? Like that. It should have an index. It should have a bibliography. It should have preface. All those features were given. So and our book had got all those features. So we then did more research on the book, and eventually we proved to the customs department that what we brought in were printed books, not only plans and drawings. The plan can be in a book also, and it can be in a glazed paper also. So I mean, it just came out of context because we are talking about technology so much. So when we are talking about this FTDR Act, so it has got the powers to make provisions relating to imports and exports. What can be imported into India? What cannot be imported into India? There is something called ITCHS classification, International Trade Classification. ITC is International Trade Classification. HS is Harmonized System. That is a book published by the Ministry of Commerce, where different chapters are there for goods. There are about 97 chapters, right? All chapters dealing with different goods. And for every item, there is a 8-digit code. And against that code, the description is given. And then the importability or not is given. Whether it is importable, something is called Open General, OGL. Earlier days we used to call it OGL. Today it is freely importable, right? Something which is restricted. For example, if it's some telecom equipment or some other equipment which is got some national ramification or which the government wants to regulate, they'll say, okay, if it's telecom equipment, go get a license from one license from DGFT, one license from DOT, Department of Telecommunications, because it is going to interfere with the bandwidth or radio waves. So therefore, there are various reasons for why regulation is needed. So all that is coming. What is the enabling provision? Enabling provision is this Section 3 of the FTDR Act, right? Under which the foreign trade policy of India is made. Now I'm just linking up from this the policy. The policy is again a document which is created by Government of India every 5 years. It's like this, about 3 books like this. It has got the entire policy, it has got the procedures, it has got the documentation, it has got the ITCHS, importability, exportability, etc. There's so much of information relating to international trade. If you want to practice international trade, this is extremely important for you, because without looking at this book, if somebody comes to you and says, can I do this, can I import this, can I export this, you cannot answer whether it is dual use or not. What import, this one section, export this other section, right? So this ITCHS is very important. So we are from FTDR Act, Foreign Trade Development Regulation Act, we have moved to foreign trade policy in that ITCHS. There are so many other angles, but I am just trying to make it simple for you so that you know what, international trade is nothing, it's no tiger. It's simple law which governs one particular kind of transactions, which is import and export. And customs law is only for taxation and procedures for import and export. But importability and exportability is through FTDR Act, read with foreign trade policy, read with ITCHS, right? So apart from this, one more important thing which, in fact, Section 5 of FTDR Act talks about foreign trade policy. It says the central government may, from time to time, formulate and announce by notification in the official gazette the foreign trade policy, and may also in like manner amend that policy. So it is made for every 5 years and amended every year, depending upon various changes which are taking place. Because you have to amend the entire thing, something which is changing or policy is changing at the government level. Somebody is going, some industrialist is going, somebody is giving representation, somebody is facing problems, or the government of India itself, they say, we don't have potatoes, let us have more potato, whatever. It can be food products, it can be industrial products, it can be consumables, it can be anything, consumer durables, any item concerned. If the policy of the government is changing, it is changing every year. But for example, if you look at this book, it says foreign trade policy for the year 2015-2020. It was applicable till 2021. Now this year they were supposed to get in a new policy, which they didn't. They said we will continue with the same. 22 also they continue the same. Otherwise, what we remember earlier, before FTDR Act came in 1991, there used to be export-import policy of India, right? So the terms were different, but the process was the same. Now, apart from this, one more thing which we need to be very careful about is the imports which can be of commercial nature, which is for business, for trade, for manufacturing, etc., or export for that matter. There will be some in the personal nature. You want to import some medicine, some camera, some personal items, some cosmetic, right? Is there a distinction? Yes, there is a distinction. The distinction is you can import through courier or postal, etc., etc. You don't need a document or a license called Importer Exporter Code Number, IC code it is called. And it's a very important control document. IC code is the first, if you want to become a foreign trader, foreign trade player, entrepreneur, you need to have the IC code, right? Section 7 of this act deals with IC code. So the policy talks about how to get the IC code, how to get it amended, how to put all the branch. A company may have 110 factories and 15 branches in different cities. So all those addresses need to be there in the IC code. And there are some exempted categories also. For example, I told you about personal imports, etc. So IC code is an extremely important document which this FTDR Act talks about. So, apart from laying down the policy on the importability and exportability, just laying down policy is not enough for the government. It has to implement the policy also. Somebody has overreached the policy and still exported or imported. Then what is the penalization? That penalization mechanism also is there in the FTDR Act, right? There are two different separate animals. If you have done some wrong, an item which is prohibited, you have exported or imported, you will be penalized and you will be prosecuted under the Foreign Trade Development Regulation Act by the DGFT. DGFT is Directorate General of Foreign Trade. That's an officer appointed by, it's a whole department. DGFT is at the helm of it, and there are many other assistant DGFTs, deputy DGFTs looking at different aspects of foreign trade policy, because they want to promote export. So there are many processes which are there, there are many schemes which are there are many benefits which are there, and there are many processes also. All this is done online. These days everything is like digitized. So DGFT is the person who does it. Even adjudication it does that. If somebody has improperly exported or imported, under this act DGFT adjudicates. And then you have an appellate mechanism where you go to somebody called additional secretary. He is the appellate authority in the DGF, in the Ministry of Commerce. It's an IAS officer. Any grievance against the order passed by DGFT, you go to the additional secretary. So that is how the entire mechanism works. So if you have tried to import or export something which is not importable or exportable, which is prohibited, for example, you import a kangaroo, right, which is an animal, without Wildlife Protection Act regulations, because the customs law and the foreign trade law, it's not in silo. It is talking with different other acts. If you are importing foodstuff or exporting foodstuff, then FSSAI will be applicable. If it's drugs or cosmetics, Drugs and Cosmetics Act will be applicable. So many acts, like different subjects have got different acts which are governing them. So we need to read them in tandem. So it is not in silo which we need to look at these provisions. So the prosecution would happen under this act. Apart from this, prosecution would be launched by customs authorities, because in Customs Act also there are provisions for confiscation. So there are dual provisions. So look at this. You are staring at three different monsters against them. One is the Customs Law, Customs Act 1962. One is the FTDR Act plus the DGFT action. The other one is the PMLA, Proceeds of Crime. I'm sure most of you must have dealt with that. I'll tell you what is the interplay between this and the FEMA, because ultimately, why is foreign trade being done? Foreign trade is being done to get foreign exchange. Foreign exchange is important. You remember 1991, those days we had hardly any reserves. We didn't have reserves for 4 months. Then we had to, the entire globalization and liberalization happened because we were very low on foreign exchange. So, today we are looking at Sri Lanka, what is happening. So, very socialistic measures, you want to support the people, you want to give all freebies, etc. It is fine. But at what cost? The country may go to dogs. So, therefore, you need to have an extremely good economic policy wherein all these regulations are in that respect only. You can have a free state where you can just be a barter state or a free state, but then you won't develop in the international arena. So, therefore, the powers for search, seizure, penalty and confiscation under section 10 of this act. That's what I was trying to drive at. So, one, it determines importability and exportability, whether you can do it or not, and if you do something, some hanky-panky, how the authorities, the DGFT and the officers who are authorized under this act can have the power to search your premises, whether it's your factory, whether it's home, anywhere, conveyance, car, bus, truck, anything, seize, impose penalty, confiscate those items. Even if it's 1,000 crore item, they can confiscate it. Then you have to fight a legal battle to show whether you're innocent or not, or what, and composition, whether it is there or not. That's a different point altogether. So these are the little aspects which I wanted to talk in terms of FTDR Act. One more important thing is control and export of specified goods, services and technology. I read the definition of specified goods, services and technology with respect to weapons of mass destruction, dual use and all that. So there's a special provision which was introduced, chapter 4A, which was introduced in 2010 later on. Because all what happened to Iraq, you remember, they were everybody thought that they had weapons of mass destruction. They had no law, etc. Saddam Hussein kept crying that there is nothing, but they were crucified, he was killed, and then later on now the studies show that there were no weapons of mass destruction. So therefore this is self-regulation by the country. When we saw that so many things are happening and the blocks, there's diplomacy in it, there's international politics in it, but then I think that this provision is a direct result of that action on Iraq. It could have happened because if you are weak, anybody can stampede you, right? So these are the controls. In regard to controls and export of specified goods, services and technology referred to in this chapter, the weapons of mass destruction and the delivery systems, prohibition of unlawful activities, Act 2005 shall apply to exports, transfers, retransfers, brought in transit, transshipment of and brokering specified goods, technology, services. So therefore, there is a restriction on that. Then there are transfer control, then there are catch-all control. There are many technical aspects to it. Then section 14E talks about offences and penalties under this act, and these are very serious. And then section 15 talks about the appeal, which can go to DGFT. And then there's a review mechanism also. If you think that you are wronged, you can go and file a review with the central government. And the powers of adjudicating authorities, DGFT, are defined. It is just like a civil court in summoning evidence, summoning witnesses, etc., etc. So it's a whole code in itself, a very short act but a very powerful act. And then this act is just a prelude to this, like 3 books like this, which talk about many other things. I don't know how much time we have.
Yeah, please continue.
Yeah. So if I talk about foreign trade policy, right? Foreign trade policy has got different chapters, right? It is divided into two sections. One is a policy document. The pink pages which I am talking, if you look at this book, is a policy section, and the white pages are handbook of procedures, because they are so meticulous. I have read many laws, I've read many economic legislation during my study as a company secretary also, in practice also, but I've never seen an area of practice so methodic and so in-depth and so systematic. I look at the Customs Act It's a masterpiece. Earlier it was Sea Customs Act. 1962 a new act came in. Every aspect of import and export, warehousing, transshipment, all valuation, assessments, everything is beautifully covered here. You don't need to look at anything. I mean, we don't need any support. In fact, even for first principle, even a judge, if a judge wants to apply first principles, the sections are so crystal clear. These days we look at acts which are so complex. Even for a lawyer, you have to read 10 times, 15 times to understand it. And if you look at sections in the Customs Act, they're absolutely simple. I mean, they're so good and so clear. And with this, and with the FTDR Act and the foreign trade policy, I think the economic institutions, especially export and import, they need to be governed in a clear manner. If law is unclear, then people would commit mistakes, and you would put behind bars those who have committed mistakes under some wrong impression. So therefore, you need to be clear. We need to be clear. We need to make law very clear, very simple. I think we need to, as advocates, it's our duty also to canvas that let us not have complicated legal systems and legal institutions. Let us have simple things, because we need to follow rule of law. The rule of law need not be in a complex sentences. It can be in simple sentences in a simple manner, direct manner. So Customs Act is one law which, if you ever pick up the BAR Act, please go through it. If you go through the index, if you go through the act, it is very clear, and it's like a song. I'm so impressed with this. And probably the first time around, I read the Customs Act, the index, etc. in those cases when we did, and I hooked onto it. I said that this is something which is very interesting. Yes, you need to do some searching, because this is not the only thing. There is a lot of subordinate legislation. There are many circulars which are coming in. There are many notifications coming in. You need to keep updated. But these days, if you have a subject, if you have a problem, you can go there and then check that. So then coming back to foreign trade policy, in the policy, the first chapter talks about legal framework and trade facilitation. What Government of India says is that, look, I am giving you a beautiful legal framework. I want trade facilitation. I don't want to punish or trouble any trader. Let it be very clear what I would want and what I would not want. So this is that kind of a document. It lays on the policy that everything is free unless regulated, it says. So therefore, when we do what we do, we look for regulations. Is it restricted? It is prohibited. It is restricted. It is prohibited. It's a study. If a client comes to me and says that, look, I am importing this particular system from Japan, right? I say, okay, give me technical literature. I'll read about that. I'll look at the picture. I'll do all that. Then I'll do a search on what? On the foreign trade policy, ITCHS. Which chapter it will get into? It's an assembly. Where does the assemblies come into? Go into? Is it a plastic assembly or is it a metal assembly? It's a technical subject. But then ultimately you need to be clear if you want to advise the client. And then you reach that particular chapter and say, okay, I didn't see any problem in this, so it is free. So I have to sign. So imagine it's just like signing a kind of an order where you think, you are certifying that there is no restriction or no prohibition on that. So all that comes from this policy. So duration of policy is 5 years, I told you. Amendment of policy is done every year. A handbook of procedures we spoke about. Objective we know, to facilitate exports and imports. And who is the facilitator? Can anybody tell who is the facilitator of imports and exports in India? Just a wild guess. I know you are not subject experts. Wild guess. Pardon me? DGFT, Directorate General of Foreign Trade. Okay, so Government of India has launched something called Niryat Bandhu, a hand-holding scheme for new exporters and importers. So it's an online platform where you can put in your queries. On paper there is so much of mechanism, and there's an intention also on the top. So what is the problematic area for importers and exporters is on the ground level implementation, right? Everybody because at any point of time I had any apprehension, any discussion which I wanted to do, any additional secretary level officer, any DGFT level officer, they were even if you walk into their rooms, they're happy to help the trade. Because if the trade is happy, it will do more, and it will help government, it will help revenue, it's a complete chain, right? So they have made citizens charter, they made online complaint registration monitoring systems, then EBRC, bank reconciliation statements. For example, this policy talks about many benefits. It talks about advance authorizations. It talks about duty-free incentive schemes, DFIA, etc., etc. What happens is that the concept is you export goods, you don't export taxes, right? And sometimes what happens, India is a hub, manufacturing hub also. You import certain components or certain raw material, etc., for manufacturing in India and re-exporting, right? When you import, customs duties are attracted. How can you avoid those customs duties? By giving an undertaking that these items will be used in the manufacture of X item which will be exported. So all that happens under a scheme, under this act. Say for example, advance authorization scheme. I want to export say 100 table fans next year. So I say, okay, I'll do my production planning, I'll make a bill of material. I'll say I need to import so many routers, so many cases, so many resistors, so many whatever transistors, etc., etc. All those items I can import beforehand and assemble in India. When I say import, what do I do? I go to the portal, I apply for a advance authorization license. I'm just trying to explain you in a practical manner. And that advance authorization comes to you. And it says it comes with actual user condition. It doesn't mean that you bring those items and you sell it in the grey market. No, you have to use it, and within a time frame you have to export it, right? If you export it, then you have not paid duties on the imported item. If you have not done all this exercise and procedure, you will end up paying, your exports will be much expensive than others. So this is what this policy is doing. Similarly, there are schemes for supporting exporters of goods and exporters of services. Even lawyers, if we do foreign work more than 10,000 dollars in a year, we are eligible for that. We are eligible for scrips. Those scrips are tradable, and we get some 3%, 4% of the FOB value. FOB value is whatever foreign exchange we are earning. 4% of it is coming to US incentives. Many a law firm, many a lawyers, they are not doing it. Sometimes when they meet me, I tell them there's a chapter, there's a process, you can apply for it, and 4% is huge. If somebody is doing say 10 crores of export revenue, 4% is 40 lakhs, right? So like that, I mean, we can gain all those benefits from through the scheme. So the EBRC is bank reconciliation statement. Whenever you are taking any benefit, you are giving an export obligation. You sign an export obligation bond with the government, right? And once you do it and submit the bank realization certificate that you have realized the foreign exchange, they issue something called EODC, export obligation realization certificate, right? So that certificate is enough for you to go scot-free. If you're not given that, then that prosecution under that FTDR Act will start. They'll say, you, Mr. X, you came, you took benefit, but you did not export. So therefore, I'm going to prosecute you. To avoid prosecution and to also maintain your exemption status, because you have taken exemption in the past, it has to be maintained. You have to do the entire circle. So how DGFT now has got a system of EBRC. From the banks, now directly it can take the realization certificates. The number, because every document you have to mention this number, license number, against which license number you have exported. So that license number will be punched by the bank. That will be picked up by the DGFT system. So it's so beautifully populated. I mean, of course there are problems, but as compared to olden days, the problems have evaporated because the transactions are so many, but still the trade is extremely happy. And of course there are certain situations when there's a COVID happening, there's something happens, you're not able to export. Then you need to go and apply for extension of the export obligation period. If that doesn't come through also, then you have to pay all the custom duty benefits you have taken with interest, etc. So there are mechanisms for protecting revenue, because revenue is compromised, because revenue thought that you will be exporting, but now you're not exporting, or you're changing your mind. So the other aspect which is a beautiful aspect is government of DGFT has signed MOUs with many state governments for sharing the EBRC data, because ultimately many benefits are there not only under the foreign trade policy. Under GST law also, if you're exporting, you get what is called input credit refund, ITC refund, right? So how do you prove that you're exported? So some states, when VAT was there, they had an MOU with DGFT that let me cross-check whether they're submitting duplicate or made up or manufactured bank realization certificates or what. So to cross-check that they need audit for audit purposes. So many government departments, GSTN network, which is a different department. GSTN comes under Ministry of Finance and DGFT is under Ministry of Commerce. They're different functionalities of the different ministries, but they do handshake through these MOUs. Then there is also now development of export-import profile. You make a profile and you submit it once. Because for many things you need to submit profile. Earlier what was happening, the exporter was making photocopies. Let me keep 100 photocopies because every application had to file a profile. So that is obviated. So the IT thing has changed a lot because many things you need to get certificates. For example, there is a scheme called Export Promotion Capital Goods Scheme. So where you can, if you are a manufacturer, you can import capital goods which is machinery. It can be 1,000 crores, right? But you have to give an obligation. What is the obligation? 6 years, 6 times. If you have brought 100 crores worth of machinery, within 6 years, you have to do 600 crores worth of export. That's an obligation you give, right? So, but then once the machinery comes, it needs to be installed in your factory. It should not go to some neighbor's factory or somebody else, or you're doing some repair activity with that or some other activity. It should be used for manufacturing goods which will be exported, which will count towards export obligation. All that is like connected. So how do you ensure that? You ensure that through a kind of a CA certificate is to be given or some cost accountant certificate is to be given. Earlier those certificates were submitted physically. Now the portal allows the professionals to upload the certificates then and there. So many kinds of revolutions have happened. These things were very, very difficult those days because if some certificate is missed in the file, you are gone. You are fighting prosecution having submitted. Then you keep proving that I have done it on so and so date, and the courts will, you know how the entire litigation system happens. It is 15 years before you get your benefit, right? So all these things, they are also allowing third-party APIs to be used, single window in customs, self-assessment in. I have not yet come to customs. I can take the days together. I think I should be faster. How much time I'm left with?
You can have.
I can have, right. So the policy talks about single window for customs, right? Because you need to keep running around. If you ever go to a government department, it's a trade facilitation with the custom house agents and for importers and all that. What is happening now is reduced cost of doing business, enhanced transparency, all these things, all the benefits. And what is happening with all this? What is happening is ease of doing business. Modi Saab keeps talking about ease of doing business, digitization, all that is seen. If we look at the policy documents and if we look at the acts also which are being amended, we can look at those terms reflected through these policy measures and legal interventions. Then there is also a self-assessment of customs duty. So earlier it was always the customs officer would assess the duty. But the transactions became so much, how many customs officers would they install at the ports? So they introduced the self-assessment process. So what happens is that you through the custom house agent file your own bill of entry and the customs looks at it and assesses the goods, whether the description is good or not, value is okay or not, whether imported details are fine or not. All those factual details are cross-checked, and there's a risk management system which is there in the IT system itself of the customs. Whether somebody is a habitual offender kind of a importer, they'll look at, then they'll order for physical examination. Otherwise, if it's a big company which is like known to do ethical business, then they'll say, okay, let the self-assessment pass through. So all those interventions also. So why I am talking about it is foreign trade policy talking about customs process, which is a different act, governed by different legislation, administered by different department, different ministry, but they're interlinked. You can't segregate customs from foreign trade policies from FTDR Act and FEMA, right? I'll just come to FEMA a bit, right? Why is foreign exchange important? Because all these activities for earning foreign exchange. In foreign exchange law, if you look at FEMA, Section 5 is the most important section for foreign trade, which talks about current account transactions. There can be two types of transactions. One is current account transactions, which is for current trade, and one is for capital account transactions, which talk about taking shares, which change your capital. If it's regular trade, give and take, buy and sell, services, that is current account transactions. I think that section is extremely important for you to know, because if you are looking at trade, if you're looking at foreign trade, and if you're looking at FEMA compliances, right? FEMA is now, there's no criminal prosecution in FEMA. Section 13 talks about only 3 times the money involved. It's only penal consequences, which is monetary penalty. There's no, after FERA has gone, FERA used to have, enforcement directorate was very powerful then. You had instances where people would just end their lives in the ED office, right? Because it was so rigorous. Their interrogation was also rigorous, investigation was rigorous, prosecution was rigorous, the punishments are also. But after liberalization, they said that look, if we can take money, that's good enough. We'll only talk about prosecution when it is PMLA, prevention of money laundering. So only if it's proceeds of crime, if it is some antiquities are being smuggled, or if some other kind of blood money is there, terrorism money is there, that was the initial intention, right? When the FEMA, PMLA came in, that was the intention. But now they have added income tax into it, customs into it, everything into it. So there's no fun. And any time the ED can start PMLA prosecution against you. So this is important. So if we don't comply with FEMA, you end up paying 3 times the penalty here also, apart from paying duties, etc. So you are facing 3 prosecutions and 3 penalties, and 3 tax you are paying, penalties you are paying to customs, then FTDR Act, they are trying to go after you, and in FEMA 3 times the penalty is there. Now, why I wanted to you to look at FEMA, the current account transaction, is what kind of transactions are covered under this. Section 2J talks about current account transactions. It means a transaction other than a capital account transaction, just like the law is in our country. Means a transaction other than a capital account transaction, and without prejudice to the generality of the foregoing, such transaction includes, now inclusive definition, payments due in connection with foreign trade, other current business, services, short-term banking and credit facilities in the ordinary course of business. This is a relevant portion to us. I am not reading the other portion. So, since it is under the current account transaction, there is a master circular which is issued, and there are regulations also on realization of proceeds. What are those regulations called? These are called Foreign Exchange Management, Export of Goods and Services Regulations 2015. So these regulations talk about how the foreign exchange should come in respect of exports. It says, you should remember that within 6 months it should come. If it doesn't come, then RBI will start action under FEMA. So therefore, you have regulators like RBI, DGFT, and customs authorities against you. If you don't complete the circles, you must have realized it, but somehow it is missed in the banking records, because the entire banking operation, RBI gets the entire information through AD dealers. AD dealers means banks. Authorized dealers have been given power. So most of the powers are with AD dealers now. Next level only you need to go to RBI, right? Even for composition, AD has been it has been liberalized. So one more aspect which is important is that person resident in India, in the FEMA perspective, who are the people, from income tax perspective also, when would your income be taxed in India, right? It's just a general concept which I thought is very important, and it will be relevant for all of us. Is person resident in India means a person residing in India for more than 182 days in the course of preceding financial year, until he has changed residence, etc., etc. So therefore, 182 days is a significant date. If your stay in India is beyond 182 days, you become Indian resident for the purpose of FEMA, and all the FEMA provisions which are applicable on residents start applying to you also. So there, you can see master directions which are issued by RBI. They are there in the website of the RBI. There are separate directions for export, separate directions for import, and there are detailed directions, different kinds of export, different kinds of import, consignment import, consignment export, then delays, how to deal with delays, and there we go granular, right? So we need a separate session for those kinds of detailed analysis. Then how to receive and make payments For that, there is a separate regulations of 2016. Foreign exchange amendment, manner of receipt and payment regulations 2016. So when you are looking at a foreign trade, you say that ये तो सिर्फ exporter है, ये तो सिर्फ importer है. We may think so, but what is that he is grappling with? He has to grapple with all these things. He or his advisors or his chartered accountant or his lawyers, whomsoever. And if there is any let up, then you land up in a prosecution which is launched by enforcement directorate, then appeal to foreign exchange tribunal, then to high court, then to supreme court, the same route. So what cases come to us, they come out of these practical situations, and sometimes the client may be complicit in it, and sometimes he may be innocent, right? So that is the little interplay of how FEMA is relevant, how current account transaction regulations are relevant, how the definition of current account transactions is relevant for the purpose of export and import, right? And going further in foreign trade policy, the second chapter talks about general provisions regarding imports and exports. So as I said, everything is free except if it is regulated. And how it is regulated? Through ITCHS classification, where the entire list of items is given, what is free, what is prohibited. You have to traverse through it and then determine on the exportability and importability. And it doesn't mean that other laws need not be complied with. For example, if you are importing any packaged item, some electronic item into India, right? So therefore, or a food item, there are laws which are applicable otherwise. Legal metrology law is applicable. What is the label to be fixed? What is the MRP to be written? Consumer complaint number? How many units are there? What is the best before use? All those things, you can't say that, look, I have complied with this foreign trade policy regulations, so I need not do it. But the regulations indirectly talk about, the policy says that you have to satisfy the other laws. Unless there are two exceptions to it, if you are bringing the goods into a special economic zone or to a foreign trade EOU, where the goods will again be exported back. So since the Indian consumer is not affected, they say, okay, we don't need to regulate them. Similarly, if somebody is manufacturing goods for export purposes, then he is exempt from all these regulations, because that country will see when the goods land in Canada will have its own regulations, and it may be more stringent, it may be more relaxed, but it is for the importer and the exporter to see. Indian government is least bothered. They say it's exported, foreign exchanges come, and how is it determined foreign exchanges come? It is determined through the bank statements, the certificates of realization, and also this needs to be submitted with the Commissioner of Customs. So he'll allow you subject to the condition, because earlier it was not there. So the customs would allow it, and it will not close the entire bond. So now they will not close the bond unless the bank realization certificate is submitted there, and customs commissioner gives in writing that yes, it is exported and amount realized. So Government of India wants export and realization also. If there is no realization, then export is not complete, and all the benefits which you are looking at would not come to you. So therefore, DGFT, India is a huge country. So DGFT, which is there in New Delhi, cannot control all the areas. So there are regional authorities of DGFT which are populated through deputy DGFTs and assistant DGFTs who govern the act and who give the benefit. Somebody is coming for a license, somebody is coming for an extension of a license, somebody is coming for extension of export obligation period. There's so much of an interface interaction between the trade and these departments. So they have different functionalities which are spread throughout the country for that purpose. And what are the mandatory documents? Import and export, we have not spoken about documents. They're very simple documents. Only 3 documents which are very important for the export and import. If we're talking about export, what is important is bill of lading. What is bill of lading? If you ever have read shipping laws, when you put the goods on the ship's hold, the ship's captain gives you something called bill of lading, that the goods have been loaded into the ship. So that document is extremely important. So every customs authority, every DGFT, every authority which is concerned, he is looking for bill of lading, because that is a proof that ship's captain has signed it. Yes, the goods have been put on the hold. It's a very factual and a very practical way. Similarly, if it's an aircraft, it's an airway bill. It's not called bill of lading, it's called an airway bill. If it's a truck, it's called a lorry receipt. If it's a railway, because now lots of transport is happening through railways, it's called railway receipt. Now goods go through postal mode also. It's a postal receipt. So these are, any of these documents is important. Then whenever there is a commercial transaction, the the important contractual document, because nobody makes contracts for trade. You go to shop, buy even a fridge, you don't take a contract. You just buy it and get an invoice, that's all. So the invoice and the packing list are also extremely important documents for foreign trade. So the invoice will give what is the price, what is the classification, what is the address, who is the seller, who is the buyer, what is the GST number of the seller, what is the GST number of the buyer, whatever the things are there. GST invoice has got certain, and the CGST Act, there are certain particulars need to be mentioned. Otherwise, these are pretty standard documents, internationally accepted commercial invoices. Packing list, why? Can anybody tell me why packing list is insisted? Okay, packing list is because every time the consignment is not only one item. It can be 1,000 mobile phones, 15 modems, 2,000 something else. There'll be the consignments have different, and it can be same exporter and importer. So packing list will give how many, what is the item, what is the make, what is the features, how many items, what is the price, what is the value. So for the customs also, for commercial also, both this is important. And the third document is the shipping document. It's a customs document. First document is a transport document, bill of lading and all. Commercial invoice and packing list are commercial document between the parties. And third document is the customs document, which is called shipping bill. So whenever you are putting exporting something, you have to necessarily create a shipping bill and submit it to the customs authorities, so that they can tally it with the bill of lading and commercial invoice and see that what is being shipped. And it is that document on which, because some items, very limited items, because if you look at duties, Schedule 1 of Customs Tariff Act 1975 talks about import duties, and Schedule 2 talks about export duties. 99.99% export duties are not there because we don't want to tax exports. But there are about 40-50 items which still carry export duties. So if there's a duty, assessment has to happen. And how the assessment will happen? It will happen through a shipping bill. Right? So similarly, on the import side, you have the bill of lading itself, same documents, because transport is the same, import or export. Just a minute. Then commercial invoice and packing list are all the same. Instead of shipping bill, in the import side, we have bill of entry. It's the bill of entry which is assessed by the customs to duty. Yes, please.
Who will submit us a shipping bill?
Shipping bill will be submitted by the exporter through his custom house agent or a custom broker.
By the exporter?
By the exporter.
So it will contain the bill of lading as well as...
Bill of lading is a separate document. It will go along with it. So these three documents, you don't, I mean, it's no complexity. These are simple documents, three documents, one from the transport point of view, one from the customs point of view, one from the commercial point of view, and one packing list. These four documents, good enough. If you want to start the export business, you have to master these documents. Of course, there are complexities within those documents, but customs doesn't want any other thing, unless there's a dispute. If there's a dispute, they may ask for technical literature, they may call you for summons, they may ask for statement, because valuation is very important. Because if what happens is that when you are talking in terms of millions and billions, there's a tendency of importers and exporters to avoid the duty. How can they avoid the duty? They can do it by undervaluation, right? And things like that. So how to say something is undervalued or not undervalued, or it can be a related party transaction. If it's a related party transaction, what is the principal thing under customs law is the tax would be applicable on goods. It cannot, services are not covered under customs law. I'm sorry. Services are not susceptible to customs duty. It has to come through port, it has to come through road, train, ship or air to attract customs duty. Services, nothing. It may be GST, etc. That's a different thing. So goods have to be there. They have to come into India. They have to cross the customs barrier of India as per the customs law. What is the customs barrier? Customs barrier is once they land in India, and there is a customs territory also. Customs territory is 12 nautical miles from the coastline. So till then, if you are exporting, the goods have to cross the 12 nautical miles. The case law of Supreme Court where the goods were like damaged or the ship got destroyed or whatever, and the goods could not be exported. The exporter was claiming export benefits. The court said nothing doing. They have not crossed the customs territory of India, 12 nautical miles. So therefore, it's not export technically, right? So similarly, import unless until they land and they cleared and they mix with the mass of goods in India, they are not imported goods. And in fact, there is no concept called imported goods. We call it very loosely. Legally, there is nothing called imported goods, because once they are cleared from the customs, they are goods. They are Indian goods. They are not imported goods anymore. Only till they are in the customs charge, they are imported goods. So it's a self-assessment, I told you. On self-assessment basis, you file a bill of entry and all these documents when you are importing any consignment, and the customs officer, appraiser on the shed, in the customs station or in airport or new customs house, wherever, they are also specialists. For food items, there is one officer. For engineering items, because everybody can't be a technologist in every respect. Medicines, pharmaceuticals and biotechnology is a separate officer. They have about many officers. There are about 97 chapters, 98 is a general chapter. So you have so many categories. You have 26 sections of goods. Under those sections also these chapters are there. And there are section notes, chapter notes, and all this is made based on HSN, Harmonious System of Nomenclature, which is published by Customs Cooperation Council, which used to be, now it is Customs WCO, World Customs Organization. So they have published that, and India has adopted that. India is a signatory to TRIPS. Being a signatory to TRIPS, we have adopted all the customs practices and the codes, because they are uniform. It will not be different in India and other countries. So therefore, at least at the 6-digit level, it is same. In India, for the ITCHS, we follow 8 digits, right? So to determine pinpointedly what, in Woodcraft case in 1997, Supreme Court held that in case of dispute on classification, HSN is the best basis authority. So therefore they have already applied mind. You don't need to reapply your mind. Though in India we have a section note and chapter note, if HSN is saying something, that's authority. That's what the Supreme Court says. So on classification also, that's how the classification is determined. If there's any problem, they interpret the notes to the customs tariff. So there's rule 1, rule 2, rule 3, etc. So you need to interpret based on, if it's very clear, then you apply the classification. If they're competing entries, then how will you do? If it's a composite item, which one will give it essential character? If it's a item which is unassembled, but in assembled form it's a bicycle, then you will put it in a bicycle form, bicycle chapter, like that. So they're sequential classification methods. After that, it will go into a particular classification, and then you pay the customs duty which is determined. And now customs duty also, it will not come from tariff. Tariff will give you a 10% rate. Generally, there are as on date, there are three customs duties which are leviable. One is basic customs duty, which is by and large 10%. And that basic customs duty is under section 12 of the Customs Act, right? So that's a charging section. And section 14 of the Customs Act is a valuation section. It talks about value being the international value as it is imported, in the form it is imported, the buyer and the seller being independent, not being related, and price being the sole consideration. So therefore, if you have paid cash, say $1 lakh and some bitcoins, so they'll say, okay, add bitcoins also. Or if you have exported something in lieu, or you have given it from some other country, so it is to be cash plus whatever you have given in kind or in the form also has to be added. If you're related parties, then they'll doubt you. There's a GATT cell. GATT means General Agreement on Trade and Tariff. In 1995, we had a Uruguay round in Uruguay, Marrakesh. So where these agreements were signed. So therefore, based in the customs department also, there's a GATT cell, which, if you are a multinational company and you have a subsidiary company in India, you need to register yourself with the GATT cell, and you have to establish beforehand that your dealings are at arm's length. That relationship has not influenced the prices. The prices are independent. It is as if it is to an independent party. So you don't worry, your customs duties are not being compromised. That's what is, yeah. So therefore, I just wanted to, because we can go technically much deeper into every aspect of it, valuation, classification, prosecution, penalties. Like for example, the appellate mechanism under the customs, the CBIC now, Central Board of Indirect Taxes and Customs, it gives a jurisdiction based on pecuniary things as to where will your appeals go to. and who can adjudicate and where will appeals go to. And the first appeal normally goes to the Commissioner of Appeals up to a particular value. If it's a very high value, it will go to the CSTAT directly. And from CSTAT, there are two branches of appeals. One branch of appeal come to High Court for matters which don't deal with valuation and duty, right? So if it's a rate of duty or valuation, then it comes to Supreme Court. So Supreme Court has, government has retained jurisdiction on valuation matters, classification matters, notification matters. That's why customs matters, some of them come to Supreme Court, and some of them come to Supreme Court via High Court. So that is for your practice. That is how it is. So no, only writ you can file, but very rarely alternate remedy is something which comes against you. But then these days GST tribunal is not there. They were supposed to make a tribunal, so all those appeals are going as writs to the High Court.
Thank you very much,
Thank you.
Srinivas. Excellent. It seems to be business international credit or encyclopedia.
No. I feel that I've just
and
not
one
even
more
covered
interesting. At midnight, I troubled him because the earlier speaker supposed to be had some difficulty in court. Then I troubled him 11:30 around midnight. So immediately accepted and he delivered. We are all grateful to you, Srinivas.
Thank you, sir.
Thank you very much.
Very much. Any questions, please?
Yeah, please. Any questions?
May I ask,
Yeah, please.
at what stage the shipping bill ought to be issued by the customs authority? And when
No,
the
customs authority doesn't issue shipping bill. Shipping bill is made by the exporter himself. Shipping bill is made by the exporter himself and submitted to the customs.
when at that stage when the goods are handed over to the customs authority, yeah, to the agency.
No, customs authority is there in the port. I mean,
Yeah, port.
you load the goods into the ship.
The exporter just,
Before that,
exporter just take the service of the some intermediary.
correct,
He just handed over to the goods to that person.
correct.
That person approached to the ICD Tughlakabad regarding the to transport the goods by railway to the home.
Myth.
At which
Cover,
stage the
close it.
bill ought to be issued? In Tughlakabad or the port?
Your invoice and packing list are commercial documents.
Yes.
They can be issued anytime.
Yes.
Right? Bill of lading is I'm coming to it. Bill of lading is possible only when you put the goods in the ship's hold.
Exactly.
Right?
Yes.
As far as shipping bill is concerned, it can be done at two different stages. Normally, before you put the goods onto the ship, you submit to the customs. They'll clear it. They say, okay, the out of charge they'll give. Okay, it's fine. You load it. Then you load it. But sometimes you want to save time. They're perishable goods, food items. If you go last moment, somebody is ill, the officer is not there, then your goods may get spoiled. You don't have refrigeration maybe. So in that case, you can file an advance copy of the shipping bill with the customs authorities.
Third question in the canteen. Please, if anybody, please, Sandeep, please anybody, it's a very complicated, I
No,
can't
it's-
say complicated, it's a very,
I'll tell you, I've attended his sessions actually.
1 minute, I'll give it to you.
Because there are various acts are involved in
Yeah.
foreign trade policy. Is there any similarity with other international countries?
Yeah, it's all the same. Of course, for something like foreign trade policy, it may be a different form, but the concept is the same. They also want export, they also want import, they want to regulate. If some drugs come, some narcotics are coming, how do they establish that? There has to be some mechanism to assess them, test them, the testing laboratories where they can send it. All those things, I mean, it's a common. Duties have to be collected. If something is coming into India, similarly, if something is going to Germany, they want to collect duties. So rates are given. So the rates may vary, the procedures may vary, documents, how they look at them, the concept is the same.
One second.
आई थिंक निर्यात बंधु जो है वो इसका प्लेटफॉर्म नोडल प्लेटफॉर्म हो
हाँ जी.
क्योंकि सब कुछ सेंट्रलाइज कर देता
So the DGFT portal is there. In there, Niryat Bandhu is one aspect, which is only for clarifying the trade facilitation.
और सभी पॉलिसी और लॉ भी
You just go to DGFT site. You have different sections. You have act or law is there. You can look at your license status. You can look at different sections like your government portals these days.
DGFT स्पेसिफिकली निर्यात बंधु इटसेल्फ कंप्लीट
It's not a portal. Niryat Bandhu is a concept. It's a scheme.
जैसे उद्योग बंधु है तो वो इंडस्ट्री से रिलेटेड हमें सारी हेल्प देता है सिंगल
वैसे निर्यात बंधु है फॉर एक्सपोर्ट एंड इम्पोर्ट.
Finally, Atulja, I request a vote of thanks. You just recovered it.
It was a brilliant lecture, and this lecture was actually urgently required also. Normally in our day-to-day life, actually we deal with criminal laws, civil laws, and but we hardly deal with the fiscal laws, commercial laws. We all want to know these fiscal laws, commercial laws. It's our desire that we should have read, but we don't bother to read. But this brilliant and short and crisp lecture was we were all spellbound. So thank you for enlightening us on this beautiful lecture on fiscal laws and on commercial aspects. It's clarified a lot of our doubts and all. And this lecture was actually urgently on fiscal laws or urgently required. So thank you once again. I have attended many of his, because he's one of the most sought after person by the corporate houses and these sessions are normally for 1 day or 2 days. But this was to the point, short and crisp.
It was very difficult to concise it.
Yes.
Concise it and link it because
Thank you.
you keep, you keep getting into different aspects.
We'll take your autograph, Srinivas.
Thank you, sir.
Next page, you take your message. Write it. I'll take this first.
Should I sign here?
Sign. Just. After this, let's have a cup of tea in the
Yes,
canteen. Next page, message.
add is small question.
In the canteen. Yeah, already it's a 4th year. Allowed to join canteen. Freely, number of questions we can interact. Please.